Okay, we've got lots of different items to start with. I should mention this is Julie, the Human Resource Director here at Concurrent HRO, and I'll be going through the presentation with all of you today. We're going to cover a lot of different items. Most of them are going to be at the federal level, so this is going to affect everybody, as well as a lot of our clients here that are out of state and not in the Colorado area. We're going to cover the federal salary exempt threshold increase. This is going into effect July 1st, as well as another increase January 1st. Now, if you are in Colorado, you're already familiar with salary exempt threshold increases, since Colorado has been having these every year annually on January 1st. Now we are looking at a very large federal increase that's going to affect all states. We're also going to review highly compensated employees and the federal threshold increase for that. We'll discuss a new federal ban on non-compete agreements. Also, Colorado already has its own non-compete, non-disclosure agreement ban, but now we're looking at one federally. We've got a few additional federal and state law updates, as well as just a brief segment on the Colorado Family Program update, a new HR benefit dashboard. So those of you outside of Colorado, I'll need you to just hang on with me real briefly while I cover that. We're also going to review what happens when an employee leaves your company and separation letters. We've noticed an increase in questions regarding this and some confusion, so I want to make sure we clarify all of that. A brief touch on E-Verify, and then also a full review of the Client Resource Center. I want to highlight some specific areas that are out there to make sure everyone fully understands how they can use that resource that is available to you. So how did we get where we are today? So back in 2016, the Department of Labor proposed a significant increase to the salary threshold. Now, what this is in relation to all salaried exempt employees. Okay, this is the minimum dollar amount that salaried exempt employees must be paid. The current amount is $35,568, and it has been at this number for many years. In 2016, they tried to raise it, aiming at a 40% increase to reach around $60,000, and then have a 3-year escalator. This never took effect. There were many appeals against it, and it never went into place. Again, in 2019, the Department of Labor tried a new rule aiming at aligning it with about 20% percentile of the lowest census region. That also never took effect, most likely due to COVID and all that came about at that time. Now, in 2024, the Department of Labor is splitting the difference, and they're setting the threshold at 35% and incorporating a 3-year escalator, which means that this amount will go up for each of the next 3 years. So what does this look like? As I mentioned, currently the amount is $35,568. We've already made sure that any of you that are in states that do not have their own minimum level, such as Colorado has the 55,000, Washington has like a 62,000. The new number as of July 1st is going to be 43,888. So if you have any employees that are between that are at 35,568, between that and 43,888, you will need to raise them effective July 1st. Okay. An even bigger increase is going to come January 1st, where you then have to raise them up to 58,656. Now, this is a very substantial increase. We're talking about $23,000 in a 6-month period. There already have been some appeals against this, and some people are making some claims. We highly anticipate that the increase for July 1st will go into effect and that will not be appealed. This amount has been looking at being increased for quite some time, and we anticipate that to stand. It does still stand a chance that perhaps that 58,000 may be lowered somewhat for January 1st, but I would still budget and estimate that that number will still increase. If it stays at that 58,656, what this looks like for those of you in Colorado, we're already at 55,000. Typically, the last few years, we've gone up by 5,000. However, beginning in 2025, we're being adjusted by the same consumer price index as the Colorado minimum wage, basically meaning we don't know what it's going to increase to as of January 1st, 2025. If the Colorado number that they come back with is less than 58,656, all of Colorado will have to be raised from 55 to 58,656. So you can basically count on at least that number, if not higher, for Colorado. We are already starting to look at the numbers, and we'll be reaching out to you, those of you from a nationwide perspective, as to those employees that this is going to affect. There are several employees in Missouri. We know we've got quite a few clients in Missouri that are going to need to be raised as of July 1st. Now, some people are going to say, well, can I just reclassify them? I'll just make them as non-exempt and hourly. That is potentially a solution. However, that's not always the best solution, because they are then eligible for overtime pay. And a lot of these employees you've got working more than 40 hours. So it's not always going to be to your benefit to just say, well, I'll make you non-exempt and hourly, because you then have to pay their overtime, and you could still in effect be paying them more than what the salary exempt is. In addition, there are positions out there that cannot be reclassified as non-exempt. They are exempt positions. So a quick little reminder on that whether or not a position is considered exempt or non-exempt is based on their job duties. It is not based on their job title, and it is not based on their pay rate. It actually, per the Fair Labor Standards Act, has to do with their duties. There's what they call a duties test that you have to run each position through. Some of you, we already help you with this. When you are looking at if they're exempt or non-exempt, we ask you to send us a job description so we can run it through the tests of administrative, computer, executive, professional. If that position is still very much an exempt position, then you will not have the option to reclassify them. You will need to keep them as exempt, and you will need to give them the increase. So lots of different moving parts with this. We want to help you with this. We want to make sure you understand it. The easiest way and the best way for you to think about it now is, if you have anyone that's salaried exempt, that is between the 35,568 and 43,888, just know that as of July 1st, you do have to increase them to at least this number. Reach out to us so we can already start having those discussions, or we'll be reaching out to you as well. Now, some other things have also come into play as we take a look at these increases in pay. The next one is taking a look at what is called a highly compensated employee. There are very few of these nationwide. Most of you do not have any of these in your company. What a highly compensated employee is there's three components to it. It is different if you're looking at a highly compensated employee in relation to a 401k. They are two different things. Quite honestly, I wish they would call them two different things, because there's two different definitions. So what we are talking about here is only a highly compensated employee in regards to the Fair Labor Standards Act. This is someone who currently makes over $107,432. Their primary duty is performing office work or non-manual work, and they perform at least one, but not all, of the exempt duties of an executive, administrative, or professional. So the majority of your employees, if they are salaried exempt, they meet all of the qualifications under either that executive, that administrative, or that professional component. So they are classified as that. But you may have somebody who customarily and regularly directs the work of two people, but they have no authority to hire or fire. But that's the only thing they do. They do some office work. They happen to direct two people, but that's it. And they happen to make over $107,000. that's going to be a highly compensated employee. Or their work is related to management or general business operation, but they can't exercise discretion and independent judgment with respect to matters of significance. If we take a look at this nationwide, they're estimating that this figure is only going to affect about 300,000. And we're talking, we've got billions of actual workers nationwide. So we actually internally as a team have been talking about this and are trying to come up with a position that actually qualifies under this. And we haven't yet come up with one because everyone we try to run past it, we're like, no, that would be a professional exemption. That would be an administrative or an executive. So we're bringing this to light because there are probably a few out there, and we're going to look specifically at individuals that are making in these amounts and their specific position to see if this affects them. But this is a very unique classification of individuals. And if some of you are thinking, oh, I wonder if this is actually me, it most likely is not, because you most likely already fall under all of the qualifications, the duties test of that executive, administrative, or professional. For this, you only meet one of them. So what does this mean? It means they currently make over 107,432. They would have to be raised to 132,964. That's a huge increase July 1st, and then up to 151,164. So we absolutely want to make sure, if we're telling you that you need to increase anyone, that they do meet this full definition, because we do realize that is a huge increase that you are having to give somebody. And we don't want to have to advise that you need to give that to somebody that does not meet the qualifications for this. Questions about this, please reach out to us. It is a very confusing area. We often have to check things ourselves. So if you do have questions or think you might have somebody that falls into this, please reach out and we can discuss that specific position and whether or not that specific employee actually falls into this category. For purposes of the 401k and just some clarification for you and knowledge for you, when you're talking about a highly compensated employee in regards to the 401k and contribution matters on that, the definition under 401k is an employee who owned more than 5% of the company at any given time during the year or year before, or regardless of ownership, will earn more than $155,000 in 2024. If an employee meets one of those definitions, they can be considered highly compensated under 401k. And then there's all sorts of rules as to what they can contribute and that sort of a thing on 401k rules. That's a completely different matter that we're not discussing today, but you can see how the definition of this is very different than the definition here. So two different things that they're talking about. Most people only know about it under the 401k rationale. All right, moving on. Let's talk about another federal item that's come into place. This most recently came out, and it is a ban on non-competes. Now, those of you in Colorado know we've already had this, so many of you have already gone through this. This is a nationwide federal ban. This rule was actually issued by the Federal Trade Commission on April 23rd. What it does is it prohibits all non-compete agreements for all employees at all levels, with only very extreme limited exceptions. And we're talking senior executives. There's a very, very limited exceptions on where you can have a non-compete. So for most intensive purposes, all non-compete agreements are void. Now, the part you need to pay attention to, because of course it's another, very long rule that was issued, is this section of 910.1. It defines it as a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from either seeking or accepting work after the conclusion of their employment. So basically, a lot of people have non-competes saying, hey, you can't go work for a competitor for over a year when you leave us. That you can no longer do. You cannot have a stipulation that they cannot work for somebody else that is a competitor. Maybe that competitor is right next door to you. They can go work for them the very next day. You will not be able to have a non-compete agreement that prevents them from doing so. This affects current and former workers, regardless of position, title, or status. And the only exception that I mentioned is senior executives. And it's what's excluded is moving forward, but any clauses entered into before the effective date remain enforceable. So you can't have ones for senior executives moving forward, but if you currently have one and you wrote it in the past, it will still be enforceable in the future. However, for all other employees, if it was a previous one that you had in place, you hired someone 6 months ago and they signed a non-compete, it will now be unenforceable, and you will be required to give notice to those workers that that non-compete is unenforceable. Basically letting them know that it means nothing now, even though they signed it. You can't enforce it when they leave. So the employer is going to be obligated to give that notice to the employees. So this is a very big change. It's a big nationwide change. And as you can imagine, there are already appeals out there, and already legal challenges to the final rule have begun. Now, the final rule becomes effective 120 days after publication. We're looking at around mid-August. Most of the challenges have been related to individuals saying the FTC does not have authority to issue this rule and that the rule itself is unconstitutional. So whether or not this ultimately ends up passing in the exact form it's in right now or not is still to be determined. But all indications have been, and all advice we've been receiving from all of our legal sources have been to go ahead and prepare yourselves now. You don't want to be caught at a last minute situation of trying to have to get this into place. So even if it's not effective yet, the legal ramifications are going to be significant. You should review all current non-compete agreements. And you should make sure that any non-compete agreements that you're signing moving forward are narrow, only protect trade secrets and confidential information. They cannot have anything in them, like I said, that they can't go work for a competitor. They should also only be used with high-level executives, not with lower-level workers, unless you absolutely have a legitimate reason to do so. We do know lots of questions are going to come in, and most often the question is going to be, do you then have a template that we can use for agreements moving forward? And we're going to give you the same advice we've been giving our Colorado clients, in that there are so many legal ramifications and intricacies to these agreements that we do request that you seek out your personal legal counsel for advice on these in drafting and putting these into place. We don't want to advise on one of these and then have it be not enforceable or too strict or too lenient, and then you guys run into issues. There's just too many ands, if, buts. And so if you are currently doing these and you intend to try to do something, seek out your own legal counsel for advice on these. But we want to make sure you're aware of them, because we have seen them from you guys, and we want you to know that you're not going to be able to do them anymore moving forward as of right now, at least. All right, a couple additional federal and state law updates. From a federal view, on June 18th, which is just coming up here in a few days, the Pregnant Workers Fairness Act comes into place. And this basically requires all employers to reasonably accommodate employees, and most importantly, applicants with known limitations to pregnancy, childbirth, or related medical conditions, barring undue hardship. Basically, what this means is that you are going to have to be a little bit more lenient on accommodations for pregnant workers. Now, most of you already do the general, ethical and moral things. Yes, you can take more bathroom breaks. Yes, we understand you can't be on your feet all day. You might need additional breaks. But this is kind of go above and beyond all of that. You could have individuals that have preeclampsia issues or some sort of other medical issues related to their pregnancy that might require some different accommodations, maybe to their working station. It could be to coming in late, leaving early, having reduced hours, those sorts of things. And you are going to have to look at those accommodations and try to uphold them. It's also related to around childbirth and really post-pregnancy when they return from having that child. There are going to be some accommodations that you have to make. So it's a little bit broader, it's more expanded. And most importantly, having that word of applicants in there, you've got to make sure that you don't have any discrimination against an applicant if you find out they're pregnant or you see them and you can notice they're pregnant, because that will be a very easy way for them to file a discrimination claim against you if there's even a hint that they weren't hired because they were pregnant. Looking at California, July 1st, California has a workplace violence protection plan. This is going to have to be in place for any employer with any number of employees. It's going to be required to establish, implement, and maintain a violence protection plan, and keep a workplace violent incident log. You also have to meet workplace violence prevention training, which is something we are currently working on developing that training and should have that ready by July 1st, so that we can present that out to any of your California employees. We also are working on the policy for this so that we can assist you and you're not having to start at ground zero. But if you've got those California employees, feel free to go ahead and reach out to us, or we'll be reaching out to you to go ahead and get this started for you and making sure that you're compliant in this area. Colorado, as of July 1st, Colorado is adding the Colorado Job Application Fairness Act. Now, we already know several things were added kind of to job postings with the Equal Pay Act. You have to post the salary range, you have to post them externally, internally. This one takes it a step further and is looking at the job application. You cannot have anything on a job application that is related to requesting anybody's age or trying to get at any indication of their age, such as what year did they graduate from college. You also can't ask them that in an interview. A lot of people will try to make it a very seamless conversation, not something intentional. You're talking about, you're interviewing somebody and you're discussing, oh, you went to CSU, I went to CSU too. What year did you graduate? You need to make sure you're not asking that question, because by asking them what year did you graduate, you can usually in some way form, oh, maybe they're this old because they graduated in this year, if they followed the path of going high school straight to college. You need to make sure you're not asking those questions, anything that can help you try to decipher their age. If you do require a transcript, some companies require those as proof of their graduation from college. You do need to notify the applicant that they are free to redact any information on that transcript that indicates their age. There sometimes is some information on there that will indicate that, such as a high school graduation date or something like that, or even a final semester. It will sometimes not say the actual dates of the semesters, anything like that. They are welcome to redact that, and it is up to you to notify them that they may do so if they choose. So that's a big one that's coming into place. And it says Colorado, this is actually starting to come through other states as well. So while I say Colorado, the salary ranges is coming into place in other states as well. These are all just following along the lines. So all you other states need to keep these in mind. They're coming your way too. Another big one is Chicago, Illinois. Now, Illinois itself has several different paid sick leave acts. There's one for Cook County, Chicago, then I know there's one other one. This one kind of ups the ante a little bit, and they are now requiring that companies have a paid leave and a paid sick leave ordinance. Basically, what they're requiring is that companies must give 40 hours of accrued paid sick leave, which most of you already do this. We've already made sure you're in compliance with this. And most of you provide the 48 hours that Colorado does, just for simplicity's sake and fairness. The additional part is the up to 40 hours of paid leave to use for any reason during a 12-month period. So where this comes into place is some of you have policies where the only thing you give is the 48 hours of sick leave for their first year. You now will be required to give them another 32 hours or 40 hours of paid leave that they can use for any reason in that first year. So they are requiring both the sick and kind of additional paid leave to use for any reason, vacation, sick, anything like that. So some of you do have some policies we're going to need to adjust a little bit to make sure this requirement is met. And we'll be looking through your policies and those of you that have Chicago, Illinois employees to making sure that your policies are up to date. But if you already know you need some adjustments to yours, please reach out to us. That always helps us to get you into our brains and forefront so we can get you to you quickly, that you're going to have to make some changes if you know this is not how your policy already works. If you've already got a PTO policy and you already give them, they can accrue 80 hours in their first year, they're in Chicago, you're great, you're covered. They already get 80 hours, it's their first year, they're covered, they got the 40/40, you don't need to make an adjustment. It's those of you that maybe give less than 80 in that first year that we've got to take a look at if they're in Chicago. All right, let's take a quick step into Colorado and the Family HR Dashboard. So this is the Colorado State Family Paid Leave Program. Many states out there, we'll go through the different states, have paid leave, family leave benefits. Many of you are very familiar with this. You've already got employees filing claims. We're already talking about these situations with you. Well, Colorado has stepped to the front and is the first one-stop shop for HR managers to keep track of employees on FMLA leave or on family leave. They have created a dashboard for you to be able to go in and basically see all of the claims. So for those of you that kind of reach out to us and say, hey, I don't know how much this employee is going to be getting from the state. I don't know how much I need to pay them for this pay period. They haven't communicated with me. That's no longer going to be an issue. You're going to be able to go in and see exactly when their claim starts, how much they're getting paid, when they're approved through. There's no more of that kind of wait until you get it from the state or the employee. Users can gain access by requesting it through the My Family Plus Employer portal. So what this means is some of you have already created accounts and have access to your family accounts. Those of you that have not already done this, you're going to want to go to the My Family Plus Employer portal and click on Create an Account. What's going to happen is you're going to see that your business is already registered. Do not try to re-register your business. We've already taken care of that because we're already making those quarterly payments for you based upon the taxes that are owed, that 0.9% that's owed. So all you're trying to do is just establish your own personal account. So what's going to happen is when you go into request information or request access, it actually comes over to us and we grant you access. That sounds a little bit backwards because it's your account and we're giving you access, but that's just the way it is because of the third-party administrator setup and the fact that we're remitting those payments for you. So we're kind of the account administrator, we'll give you access. Now, that's just access to the account. Each account can then have 2 what they're calling HR benefit admins and up to 6 HR benefit viewers who can basically just view things but not really do anything. There is a whole article about this and kind of talks about it directly on the family website. When you get this presentation, this will be a link you can just click on and it will take you right to the site, or you can go right to the family site and it's on their homepage. There's also videos you can watch that they did a webinar on it. Some items to note. As I mentioned, your account is already established. Please do not try to register your business We already did that. And if you try to do that, it's just going to mess things up and can create lots of problems that we then have to try to fix. So save yourself the trouble and us some issues. You only need to create your account. Once, as I mentioned, the request comes over to our tax department. They give you permission. Deb tries to do this very quickly when she gets the request. It's usually within a few hours unless she's in a meeting or something. But she does try to grant it just as quick as she possibly can. And please don't change any emails or contact for your actual full account if it's related to payments or wages. This then makes it difficult for our accounting department to place those payments. So try not to change any of that, just so we make sure notices on payments and wages and stuff still go to them. If you're looking at the user guide, which is also, you'll find it when you click on this article, there's a link to it. You basically begin with creating your account if you haven't done so. And then in that user guide, you're going to skip to number 7, which is the HR dashboard, and it's on page about 43. All of the pages before 43 talk a lot about how to submit payments, how to submit wages, how to set things up, all the stuff that's already been done and you don't have to worry about. You're wanting to get to the HR dashboard. That's going to start on page 43. And we are requesting, if you are comfortable doing so, to please add us as an HR viewer so that we can view the claims as well and assist you, because often you guys ask us lots of questions, which is fabulous. And it's going to just help us be able to assist you better if we can actually go in and see those claims as well. And so we are asking if you can add us in our HR email, hr@concurrenthro.com, as a viewer user. We certainly don't want to have to go in and change anything. We just want to be able to go in and see those claims as well. So I have given you some screenshots here of how the dashboard looks. This is how you manage the benefit users. You can see, you'll see yourself right away. When you put yourself in, you're going to be the HR benefits administrator. As I mentioned, you can add up to 2 of you, so you can add another user. It will ask you if you want them as an administrator or a viewer. You can have up to 6 viewers. Make sure you're not adding managers to this. Managers don't need to see claims. You really do want to keep this to people that are in HR positions or COO, CFO, those type of positions. Really people that are in more of your executive type positions, and really individuals that need to see claims. Usually there should only just be a couple people on here, unless you have a huge HR department. When you go to do it down here, it's going to ask you about which security you want. And then one of them down here, it's hard to read, but it's going to ask you the access type. One of them says absence and leave management company. That's what you're going to want to click for us. For us as your TPA, your third party administrator. That's kind of what they're calling us, is the absence and leave management company. You'd click that when you're going to go through and add us. And then it takes you through the process. Once you get to the claims, this is what your claims dashboard is going to look like. It will have first name, last name, social securities, when their leave starts, the claim status, if it's pending, complete, it's currently active, they're out on leave. And if you click view, you're going to be able to go in and see the entire claim, when it starts, when it ends, how much money they're getting, all of the good details that you guys really are concerned with. And so we've heard so far great things about this from the division. The response they've gotten is overwhelmingly great. So I think you guys are all going to really enjoy it, and highly encourage you to get yourself added in there as users to, it will only help you. Couple other states, just so you guys are aware of, that still do have those paid family leaves, and some ones that are upcoming. Of course, California, Connecticut, Delaware is going to be added in 2025, Maine 2025, Maryland in July of 25, Minnesota is coming in 2026. All of these other states on here are already active and have plans. So if you know you have individuals in these states, please be mindful of that. And if you have individuals that are going out on some sort of leave that is related to their health of a family member, pregnant, maternity, paternity, situations like that, there is most likely paid family leave benefits that they can get from their state if they're in one of them. All right, let's talk a little bit about when an employee leaves your company. There has been a lot of confusion around this, and we want to make sure that we clear up all of that confusion. So regardless of why an employee is leaving the company, if it's voluntary or involuntary, all states except for three, and they're three very little states, I think like Rhode Island is one of them, require employers to provide a letter or form to the employee that contains certain information related to their hire date, final pay date, benefits termination, how to file workers' compensation information. The actual letter or form you provide isn't as important as long as you provide the necessary information. So we have made this very easy for you. We created a template letter for you to use, and we have created one for every state so that it already has the appropriate unemployment information on there, and you don't have to go out and seek what that information is. You just have to fill in all of the other parts. So this is very important for you to know. Even if the employee is voluntarily resigning, they have to be provided this information. And part of it is how to file unemployment. Now, a lot of companies say, well, why would I tell them how to file unemployment? They quit. I agree, doesn't logically make sense, but there are reasons why even individuals that quit can get unemployment in certain circumstances. So the information just has to be given to them. So what does this letter look like? Well, for one, where can you find it? It is in the Client Resource Center. We've made it very easy. It's under Answers, and it is the very first thing that shows up on that page. We call it a separation letter. We found when it was called a termination letter, it was too confusing. People thought they just had to give it when somebody was being terminated. No, it's a separation when they leave the company. And as you can see here, we have them created for every state. So you just need to click on the state that you need it for, and up will pop the template for you. This is what the letter looks like. You fill in their name, address, email, last four of their social security number, their name, company name, date that they're, separating, and reason why. If they're resigning, it can say due to your voluntary resignation. If they're being terminated, it can be to policy violation, absenteeism issues. There's lots of different words you can use. If you're having troubles coming up with the right verbiage, reach out to us. We'll help you out. You're going to tell them when their paycheck, when they're going to get it, and hours worked through, if they're being paid out anything of PTO vacation, if they have health benefits that they go until the end of the month, whatever month they have their last day. That unemployment's on there, their dates of employment, year-to-date earnings, and wages for the last week worked. Now, some of you also often question and say, well, I don't even know where to find any of that information. Fabulous question. I've laid it out for you here on this screen. Their address and last four of the social security number you can find on the personal tab under their profile. Date of final paycheck, discuss and confirm that with your payroll manager when that's going to be. Same on PTO or vacation payout, discuss the amount with your payroll manager. Although some of you that track it on your own, you're going to know that amount. Benefit end date. Well, the first question is, do they even have benefits? Because if they don't have benefits, you can completely erase number 3. You don't even have to have it on there if they don't have benefits. To see if they have benefits, you go to the action bar, which is on their first page. It's kind of in the upper right-hand corner, and then click on benefit overview, and up it will pull and it will tell you whatever active benefits they have. So if they have anything that's beyond what's employer paid, you're going to want to say that their benefits will end the last day of the month. Dates of employment, that's going to be on their main screen. Year-to-date earnings, go back to that action bar and click on payroll summary. It pops up. Wages for last week worked. This is simply the number of hours the employee worked for that week and multiply it by their hourly. If it's Monday, they only worked 8 hours. It's 8 hours times their hourly rate. Keep in mind their year-to-date and wages for last week worked may not total their entire wages. Depending on your pay cycle, there could be a whole nother week that's not being accounted for in these two numbers, and that is okay. Their final wages are going to be verified by the request for facts for the employer or the employee via their final pay stub. They're just kind of looking at getting an estimation here. So when these don't add up to everything the employee actually gets, don't stress, don't worry about it. It's absolutely okay. They're just looking for at that point in time, what are those numbers? You can also always reach out to us or really your payroll manager, and they can help give you some of this information as well. Real quick on E-Verify, we've done a huge blast out to some of you regarding E-Verify in all of the states where it's required. A couple things we just wanted to mention is if you start the E-Verify process, it is not required nor allowed to do E-Verify on any employee already hired. So if we reached out and said, hey, you have somebody in Florida, you need to do E-Verify, and you come back and say, well, that person's been there 5 years and we're not hiring anymore, then we're going to let you know, okay, then you probably don't need to do E-Verify if you're never going back into Florida, because you can't do it backwards. You only can do it forwards. We do, though, say sometimes it's good to go ahead and get the process started and just create it. So if you do end up in a state that needs it, you've got it there. But if you don't plan to hire in any employees in the states that it's required, you don't have to begin E-Verify. And you still have the options of processing it through the E-Verify site itself. It's a manual process. You do it yourself, but it is very easy. Or you can process it through us and Prism HR automatically after you sign off on the side 2 of the I-9. There is a $3 per new hire charge. If you do want to do E-Verify through us, you just go to the online forms and there's a form to fill out to get started. Here's all the states in which E-Verify is required. All employers in Alabama, Arizona, Mississippi, South Carolina, and then a lot of these other ones, it has certain conditions. If it does say a number of, 25 or more employees, this is company-wide, not just saying 25 employees in Florida. So if you've got employees in Florida, you're hiring in Florida, and you have more than 25 employees, you are mandated to do E-Verify. That's kind of how these read. So these are the different states that do have it required based on other stipulations. All right, let's jump over to the Client Resource Center. This is our last section I wanted to highlight for you. A couple of pointers that I want to make sure every single person is aware of. We created this site for you, for your benefit, so that you could easily access forms and templates without having to reach out to us and ask. We want to make it user-friendly for you. We want it to have information that you need. So we're always updating it. If there's information that you're like, wow, I wish they had this on there, please let us know. But this site is completely separate from Prism HR. Prism HR is the HRIS system. We don't have any flexibility really on what we can add or kind of program to that. So it is a website. Outside of that, it has a separate login and password. The login is always going to be your email, and then of course you create the password. We highly encourage you to bookmark the site so that you have ease of access to get to it. If you don't, you can always go to the concurrenthro.com website and click on it, or all of our taglines have it right below, looking for forms and templates, click here for Client Resource Center, so you can always click on it there. This is intended for HR benefit payroll departments, not necessarily managers. We want your managers, if they're doing progressive discipline, to reach out to you to get that form from you. So we're going to jump over there real quick, and I'm just going to show you a few different things so that you can see. Hopefully this is, I just want to double check. Okay, I'm sure it's going to show up. Do you hear? Okay. So this obviously is the home screen. kind of just shows you some different things, but really the areas you want to be concerned with are right here across the top. The online form section. This is where it's got all the forms that you need to fill out if you're sending something to us. Leave of absence. This is a huge section where clients have questions on. I don't know the process. We're going to go through the process in a moment, but one of the big pieces is that you have to tell us the employee's going on a leave of absence. And you do that by filling out this employee leave of absence form. We change it in the system so it shows they're on a leave of absence so it can be tracked. When they return, you go to the change form and return them to active. Change form is also for pay rate changes, position changes, title, all sorts of things. Manager access, quick onboarding, the termination form when you need to terminate someone. If you have a new worksite location or a new position you need to create, background check request, or as I mentioned, if you want to start the E-Verify process, that form is here as well. I'm next going to jump to the answer section because this is the second most used area. As I mentioned in the answers, the first thing to pop up is those separation letters. Someone did ask if there's a different separation letter to give to someone that's retiring. Nope, it's the exact same letter. You're just going to say your where it says, why are you leaving? You're going to say you're leaving due to your retirement. That's why they're leaving. So same exact letter. We've got the employee warning. If you're going to give somebody a written warning, we've got a template, a PIP template, exit interview questions. There's some payroll. If you're ever wanting to know what the final wage rules are for a state, we've got that listed. Overtime rules for states. There's some benefit ones in here. And this is really the heavily used section of HR answers. We have a job description template, or one, if you're ever wanting to know what all we can provide for you or help you with, there is an HR services guide here. And this tells you all the different areas in which we can assist you and help you. Most of these you're paying for. There's only a couple that are additional fees, and that's with the partnerships that we have for Clear Company, Jazz HR, or background checks. Otherwise, everything else is included, so you can check that out. But we have job description templates, job posting, offer letters, performance management. We have evaluation. The big one, leave of absence, FMLA. Medical inquiry form, this is highly used. If you have somebody that might need an accommodation going down the ADA route, this is what the medical inquiry form is used for. Or if you're really just trying to verify that somebody has a leave of absence and that it's medically related and maybe your company doesn't qualify for FMLA, you could also use that form. This request for leave of absence is also an internal company form you can use. It basically is a formalized way for the employee to request, hey, I want a leave of absence on this date. I'd return on this date. It's a formal way for you to say, yes, this is approved. No, it's not. And most importantly, one of the requirements when they go on a leave of absence, if they have benefits, is they have to complete the leave of absence health premiums agreement. Are they going to use PTO and sick time to cover their premiums, or are they going into arrears, making sure they're aware that as soon as they come back, that amount is deducted out of that first paycheck? So you guys are always looking for this. This is where this is. We also, in the family section, have very detailed instructions, not only for the employee, but for you yourself. So you can read and know step by step what you need to do for that employee. And the employee one is great. You can just give it to that employee, and it also gives them step-by-step instructions on how they need to file their claim and what they need to do for you as well. In addition, we've got the medical release return to work, EAP information, and also trainings. I wanted to cover this real quick because we've been doing a ton of trainings and want to make sure you guys are aware of them. A lot of our trainings are done by our HR department. If you're local, we can come on site, or we love to do them over Zoom so that we can reach everybody anywhere, and we make them interactive and participatory. We've got them on time management, how to be effective supervisors, leading and motivating teams, documentation, progressive discipline for supervisors, coaching and performance management, diversity inclusion, how to interview job applicants, workplace harassment and bullying, conflict resolution, and then, as I mentioned, we'll be adding that workplace violence training as well. These are all ones that we do. If you're looking for one that we don't have, always feel free to reach out and we'll see if it's an area in which we can develop one. And then if you're looking for one that is more of on demand, it gets pushed out to your employees and they kind of complete it on their own. It's more the video type one. We do have some on-demand trainings that we can push out in these areas as well. So we want to make sure that your employees and your managers are getting support and trainings in areas that they need or that you would like them to have. And so we just want to kind of quickly review and make sure you guys are also aware of that feature that we offer for you guys. There's no additional price charges for any of these. This is part of what you guys already have available to you. And so we would love to provide those trainings to you if it's something that you're interested in. So with that, that does come to the end of the presentation. Would love to answer any questions anybody might have. Feel free to type them into the chat box, or if you'd like to unmute yourselves, you are welcome to do so at this time.
I just wanted to say thank you, Julie. This was really great.
Oh, thank you so much, Tammy. I appreciate it.
Hi, Jolie. This is Mihal, and I was going on to the Family Plus Employer site, and all I see is like sign in with login.gov. I don't see where it says for me to request permission.
Yep. So I'm going to hop on over there for you real quick here, and I will show you. So you are going to go to, if you click on the login to My Family Plus Employer, and then they kind of hide it. It's right here. Are you a new user? Create an account.
Okay.
You'll create an account, and it's going to lead you through the process of creating one. And as you go through that, it has you put in information that then sends account permission over to us to give you access.
Oh, okay, thanks. I got confused when I saw that, and I thought, well, you said don't create a new account because we already have an account. Okay.
It's okay, everybody. It is confusing. This is just for you to create your own personal account.
Okay.
If you actually have to create a business account, it looks a little bit differently. It will take you to a part in there, though, when you're creating yours as to if you need to register your business, and that's the part you don't want to do.
Okay, perfect. Thank you.
You're welcome. Another question, who do I contact to get into the Family Employer? I don't show that I have one connected. Want to make sure. So same thing. If you first of all go in and create an account for yourself, that will automatically, as you go through that process, it will stop you at some point and say you need to request access. That access will come over to us because we are linked to your account. So that will automatically come over to us. If you go through that process and it doesn't do that, certainly reach out and let us know, but it should automatically do that once you get through that, creating a personal account for you. If it doesn't, Pam, reach out, let us know, and we'll make sure you get connected. All right. Well, I don't want to take any more of your time. If you have questions, of course, please reach out to us. Let us know. That's what we're here for. We so appreciate our partnership with all of you. We enjoy working with you. Hope you found some value in this today. As I mentioned, I will send out a copy of the recording as well as a copy of the slides that will come out later this afternoon. And I hope you all have a fabulous day and rest of your week. Thank you so much.